On 23 June 2016, a UK-wide referendum produced a majority in favour of leaving the EU, and the government then announced its intention to trigger Article 50. The issue in these proceedings have nothing to do with whether the UK should exit from the EU or the terms or timetable for that exit. The main issue is whether the government can trigger Article 50 without the prior authority of an Act of Parliament. The other issues concern the obligations of the UK government under the devolution legislation before triggering Article 50, and in particular, whether the legislatures in Scotland, Wales and Northern Ireland must be consulted. So far as the main issue is concerned, as a general rule, the government has a prerogative power to withdraw from international treaties as it sees fit. However, the government cannot exercise that power if it would thereby change UK laws, unless it is authorised to do so by Parliament. The claimants argue that as a result of leaving the EU, UK law will change and legal rights enjoyed by UK residents will be lost. Accordingly, they say, the government cannot trigger Article 50 unless authorised by Parliament. In reply, the government argues that the 1972 Act does not exclude the power for ministers to withdraw from the EU treaties, and that Section 2 of the 1972 Act actually caters for the exercise of such a power. Today, by a majority of 8-3, the Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so.